people back out on the street, if they can commit additional crimes, that is not helping these communities.
Which accused criminals have to wait for their trials in jail and which get to be free during that process? You're probably thinking, well, that depends on the crime and flight risk, and that's true. But out on bond also currently involves whether someone can afford to pay that bond. This week, Miami-Dade's criminal court community suspended a rollout of a reform plan that would address that and other issues after the governor in Miami voiced his opposition. Right there, Miami-Dade's administrative judge, Nushin Sayfie, has been working on that bail reform plan right here with us live. Your Honor, Nushin, great to see you.
Good to see you too. Thank you for having me.
So the community hears the words bail reform and gets a little skeptical. You've seen that. And so I want to take a moment for you to talk about what factually does this reform mean? Because the law is the law, right? You've got to follow the law.
The law is the law, but I think, as I've said many times now to anyone who wants to listen, we don't refer to this as bail reform because we are not eliminating bail. That was never part of our proposal. And calling it bail reform, frankly, was number one, it's sort of a loaded term because it refers to a lot of what's been going on across the country. And that's not going on here in Miami. It's never been part of what our proposal was. So the elimination of bail it's never been on the table, and bail reform really didn't refer to what we were doing. What we were seeking to do, and frankly, this is the most recent endeavor, was a culmination of, honestly, a decade-long effort that started with my predecessor, Chief Judge Bertie Soto, and was joined in largely by our our state attorney, Catherine Fernandez-Rundle, to address some of the deficits that the governor brought up, and very specifically that there are many people in this state right now, certainly in Miami right now, that can get released on bond without seeing a first appearance judge. And these include people who are charged with crimes like DUI manslaughter, or burglary of a home while occupied, or aggravated battery with a firearm.
Serious crimes, violent crimes.
Career criminals, correct. And I think that, you know, we've been trying to address this issue because it's been a real concern for public safety as it stands. Public safety has always been the #1 concern, and bail was never going to be taken off the table.
So it sounds like, I mean, what you're saying almost sounds like you're making it stricter or more stringent, but I know that there is a real money component because right now it's an affordability. You know, justice isn't served if someone can't afford the bail. So right now, talk about the financial component to this.
So our current practices focus just on the financial component, in that when somebody is arrested, if they can afford to make the bail, they can bond out without seeing a first appearance judge. And that's without regard to their prior history. That's without regard to whether there's a victim in the crime. That's without regard to if they have a history of failing to appear. It's focused just on whether or not they can make the bail or not. And what we were hoping to do and what we're planning on doing, and frankly, what the governor's proposals will hopefully assist us in doing, is making better decisions and having more people go to first appearance hearing and see a judge so that the judge can make a determination based on not just their financial ability, but frankly on the nature of the offense and the nature of their history. If there's a victim involved, the judge could consider maybe a GPS monitor. The judge can certainly warn the person to stay away from a victim. There's a whole host of things that the judge would be able to do at a first appearance hearing in a lot of these situations that we currently don't get to do because people have the ability to bond out without seeing the first appearance judge.
All right, so help me through this, because the governor came to town. It sounded like he was criticizing that kind of plan. My perception, and I'm not saying that's a fact, but that's what it certainly sounded like. And the governor launched his own plan, which will go through the legislature. And I just want to throw out some of his proposals, such as limiting who is eligible for release before first appearance, making sure judges make the ultimate decision, require detention hearings prior to trial for dangerous crimes, and petition the Florida Supreme Court to establish a uniform bond schedule. So that's the plan, and it sounds like it's the same as what you're talking about.
So I mean, I think part of what was going on was that, you know, I think the one thing that we could have done better and should have done better and will hopefully do better in the the weeks, months, days ahead, is to make the community understand what we were trying to do, because you're absolutely right. The four main proposals the governor made were proposals that we were very specifically addressing in our plan. Now, number one thing he said is that there should be no elimination of bail. And as I've said all along, we were never going to eliminate bail. Bail would still be in the toolbox for a judge making the appropriate findings to make. The governor said that more people should see a first appearance judge. They should not be eligible for release without seeing a first appearance judge. And that was honestly a hallmark of our proposed plan, was to have a list of offenses. We had over 700 offenses on this list. Most of them are currently not on the list, where the requirement for a first appearance hearing would be there. And then that's part of what the governor stated. He also stated that judges should be the decision makers. And again, that's honestly very much a hallmark of what we were trying to do. We wanted more people to see a judge, not bypass the judge by just bonding out, because that way the judge can make meaningful decisions. And our other hope was that with a public safety assessment, the judge would have just more information to make a very meaningful and important decision that would absolutely improve public safety. So you're not wrong. We're very much in line, frankly, with what the governor's proposals are.
So tell me, help us kind of, where does this fit in with what a lot of skeptics and fearful community members call a revolving door? You know, that's kind of a catchphrase and almost a cliche, but frankly, you know, we have covered people who have committed a crime, have gone to jail, have been released on bond, have gone back to the scene of the crime, committed another crime, and whether these are minor or major crimes, which probably happens in both accounts, this creates what people call a revolving door with criminals in the community. How does this fit in with this plan?
So I want to say again that I think part of our messaging, we did focus so much on the major crimes. It wasn't that we weren't focusing on the minor crimes. I think that we should have let the community understand better what we were trying to do. These are not small concerns. I don't want in any way the community to ever think that those are concerns that the judiciary or anyone else thinks, you know, certainly not the state attorney or anyone involved in this project thinks are small concerns. Those are serious concerns. And our plan was addressing those concerns certainly better than we currently do, which is that every single person who's arrested, even if it's a minor misdemeanor, would be assessed. And in many of those situations, based on the person's history, certainly if they're a revolving door, arrestee, that would be flagged and they would then be required to see a first appearance judge. So again, it's an improvement on our current practices, which, you know, do have somewhat of a revolving door. And it would take into account, you know, not just the seriousness of the crime, but also if the person had a history of failing to appear. So again, it'd be one more piece of the puzzle. The other thing that we did is we engaged in this process, the Homeless Trust and the Thriving Minds Behavioral Health Network, which is our local mental health provider. And we had them at the table so that hopefully this revolving door person who's at first appearance, we could start at least trying to attempt to address the reasons why they're in this revolving door and maybe cut it off.
So real quickly in the 30 seconds we have left, what now? You just wait for the legislative packages to be rolled out and see how that comports?
We were honestly about 3 to 6 months away from really being ready to launch anything anyway. So we were sort of in a, we were that's part of the reason why we didn't do, better community messaging. And I welcome the opportunity now to do better with community messaging. But certainly we have to pause. The governor absolutely put it out there to the legislature, to lawmakers, and we are law followers. We, the judiciary, the prosecutor, the PD, everyone involved, law enforcement has been at the table. We follow the law. We don't make the laws. We work within the parameters of the law. So in the event that there are going to be new laws that are going to help us do our job, we're going to work within the parameters of those new laws, and we're going to do the best we can to serve the people of Miami-Dade County.
Judge Nushin Sayfie, Miami-Dade Administrator of the Courts. So good to see you and have you aboard. Come back soon.
Thank you very much.